If you're studying criminal law, or you're just a fan of cop shows and legal dramas, then you've likely heard the terms parole and probation thrown around a lot. But have you ever wondered what they actually mean? Are they just two terms that can be used interchangeably to describe the same punishment, or is receiving one of them worse for a convicted criminal than the other? Well, grab your gavel because court is in session, and on the docket is parole and probation. You, the jury, will have to define what the difference is between these two concepts and why it's important to stay aware of them both. On a basic level, probation and parole are the two sentences that serve as alternatives to an offender being incarcerated in prison. One of the key similarities, and possibly the source of confusion for some people, is that both of these punishments involve the day-to-day actions and behavior of an offender being supervised and monitored. This means that regardless of whether someone is sentenced to parole or probation, they still have to behave within the confines of the law or run the risk of facing further penalties. So let's start with probation. In some cases, when a crime has been committed and the accused person is found guilty, any prison sentence intended for the convicted offender can be suspended in favor of probation. This is a punishment passed in a court of law. The decision whether or not to grant probation to a convicted offender or a criminal suspect is made by the court but granted by a judge in place of a prison sentence. The maximum term for a probation sentence is 3 years, provided the offender follows the set conditions of probation. If not, they run the risk of garnering themselves an additional charge of breaching probation. This is only an option in specific cases too. It's not like anyone found or pleading guilty to any crime can just be awarded probation. Usually, it's offenders who have no prior criminal record and are accused of non-violent crimes that are the most likely to receive probation. However, this is at the discretion of the individual judge presiding over their trial. Something as seemingly insignificant as an accused offender acting in a way that a judge deems to be disrespectful or unpalatable could spell the difference between receiving jail time or probation. If receiving a probation sentence, a criminal is released from police custody and permitted to remain a part of the community. This means living outside the walls of the prison, but only as long as they maintain a standard of good behavior deemed to be acceptable by their probation officer. A probation officer is someone whose job it is to supervise the specific conditions that an offender on probation has to abide by. These officers, while technically a facet of law enforcement, are not members of the police, but are instead specifically assigned to those on probation in order to help them and offer them support with rehabilitating offenders, as well as assessing the likelihood of reoffending in the future. An offender with a probation sentence will regularly meet with their probation officer to discuss the requirements of their sentence. For example, if one of the conditions of probation is that the offender in question must attend counseling or therapy, then their probation officer will advise them on where to go in order to receive the necessary type of treatment that they're required to undergo. This is typical of supervised probation, which, as its name suggests, is probation wherein the offender and their compliance with the terms of probation are overseen by a supervising officer. There's another type of probation, referred to as unsupervised probation, wherein an offender does not actually have someone monitoring them. This is slightly laxer than the supervised variety, and in general, the only requirements expected of those in unsupervised probation are that they do not commit any further criminal offenses and maintain the payment of any court costs or penalty fines. The duration and severity of probation are largely dependent on the good behavior of a convicted offender. Any specific conditions that they have to abide by are set by either their probation officer or by the judge who presided over the trial. The actual probation begins shortly after conviction, and during the supervised period, the offender must follow the rules that they're prescribed by the court and are enforced by their allocated probation officer. It's important to note that the granting of probation is something decided on a case-by-case basis, and there is no concrete formula for being sentenced to probation. It's also nearly impossible to predict what an offender's probation will entail, given that the decision to grant probation requires careful selection, supervision, and an assessment of what might come of releasing the offender. Some of the conditions entailed in a person's probation can differ regarding the particular offense that they committed, but given that probation is an alternative to serving jail time, you're not likely to see extremely violent criminals getting sentenced to probation. As for what the actual period of probation entails, this too can vary depending on the severity of the crime that the offender has committed, ranging from performing community service, paying court-mandated fines, regularly checking in with their probation officer, agreeing to not consume any drugs or alcohol, and attending counseling. So, if that's probation, what's parole? Sometimes referred to as supervised release, the key difference between probation and parole is that in the case of the latter, an offender has had to serve a portion of their sentence in prison first. If they are then granted parole, these inmates will be released from jail either on a temporary or permanent basis sometime before the completion of their sentence. Parole is usually granted only if an inmate displays good behavior during their time in incarceration, allowing them to be released before their full sentence behind bars has elapsed. Simple, right? But there are still a few important nuances to consider. For example, when an offender is temporarily or permanently released from jail on parole, the conditions of that parole aren't dictated by a judge, but are rather set by the parole board. If someone is serving a federal jail sentence lasting 2 years or longer, these decisions are passed to the National Parole Board, which will decide if this offender deserves to be granted parole. If the board decides that they do, then they're in charge of determining the conditions surrounding the offender's release and how they're supervised going forward. After all, just because parole means an inmate is no longer behind bars, it also isn't a get-out-of-jail-free card. Being on parole doesn't mean someone has got away scot-free. It's still part of their sentence that they're obligated to serve. Any inmate seeking parole must make a formal application to the National Parole Board in order to be even considered for full parole. If granted, this will allow them to serve the remaining portion of their prison sentence within the community while under specific conditions and direct supervision. Naturally, not every application is granted parole, and the board has to assess carefully whether or not an inmate seeking parole poses any potential threat to society or carries any risk of re-engaging in criminal activity once outside. As a result, their criminal records, their behavior within the prison environment, and any plans that they have after they're released are all taken into consideration before any parole can be granted. There's even some consideration given to those who have committed more serious offenses, including murder. However, this only comes if parole applicants meet even more specific criteria that prove they no longer pose a danger to the people around them. One common form of parole is known as statutory release, meaning that an offender must be released for the final third of their sentence so that they can complete this remainder within a community outside of prison. In these circumstances, statutory release is not the decision of the National Parole Board and is instead made in accordance with federal law, but it often carries with it many of the same conditions as more typical cases of granted parole. As well as being supervised, parole is a highly conditional release from prison. When it comes to what the conditions of parole are actually like, the primary goal of these limitations placed on offenders is to make sure the community they'll be reintroduced to is safe from the offender while on parole. Many who find themselves granted parole aren't just left to their own devices. They'll have to regularly attend meetings with their parole officer. In addition to this, as well as generally obeying the law, parole cases often come with similar restrictions as probation, particularly when it comes to prohibiting the offender from consuming alcohol or drugs. Depending on the original crime that was committed, along with a number of other factors that need consideration, the conditions of an offender's parole can range wildly in how strict they are. The National Parole Board can decide to send a convict to live in a halfway house instead of allowing them to return home to live with their family or friends. A halfway house, as the name implies, is a facility designed to house other offenders as they spend the remainder of their sentences on parole, acting as the halfway point between coming out of prison and living among the innocent people again. Additionally, the board might decide that an offender has to attend check-ins with their parole officer multiple times a day, either in person or via telephone calls. Parole is often supervised by federal correctional services, although it can sometimes be overseen by private companies such as the Salvation Army. In some cases, released inmates are mandated to avoid contact with certain people, whether these are the victims or family members of the victims that their crimes might have affected, or other associates that might encourage the offender to once again break the law. There are also typically restrictions on where an offender can go while on parole, with most not permitted to leave a specific area, whether that be a town, city, or state, unless given the express permission of their parole officer. One common misconception surrounding parole is that it is a reduction in the overall length of a convict's prison term. That isn't quite the case. However, as while they might not be serving time within a prison environment while on parole, an offender is still considered to be serving the remaining time of their sentence while living in the community rather than behind bars. They have to serve the remainder of their time rehabilitating themselves and reintegrating with society, typically by seeking out new gainful employment or performing community service, if the terms of their parole say so. Much like those on probation, any failure to comply with the rules given to an offender by the parole board will result in them being sent back to prison and made to continue serving their original sentence. The ultimate purpose of parole and probation alike And another way in which the two overlap is that they exist to facilitate a safe reintroduction of those who have been convicted or who have pled guilty back into society. When it comes to parole, it's the job of supervising officers to make sure their allocated offenders are taking the necessary steps toward reintegration and that they're reducing their recidivism, which is the term given to the potential risk of these offenders committing further crimes. An important reality that those out on parole have to remember is that their newfound, albeit limited freedom can be revoked at any time. If at any point the conditions of their parole are violated, or if they commit a subsequent criminal offense, they can be taken back into police custody and sent straight back to prison shortly after that. After experiencing the slight reprieve of no longer being in that confined environment, having to return to incarceration can be devastating, especially as in some rare cases, even a minor, earnestly accidental infraction of the parole conditions can be regarded as a violation by more frugal parole officers. There are a few more common ways in which parole is violated. One of these is if the offender should leave the vicinity of a specified area in which they were required to carry out their parole. In some cases, offenders will require permission to move or travel, or might even be prohibited from interacting with certain places or people that the National Parole Board, often indicated by the offender's own history, associates with criminal activity. For example, gang members on parole would not be allowed to communicate or visit other members of the same gang. That kind of seems like a no-brainer, really. Not committing another criminal offense is also a basic condition of most parole cases. While in some instances there are no doubt offenders of violent crime who use their parole as an opportunity to repeat offenses in a similar way to their previous crimes. Some of the more common offenses that led to parole violations have to do with substance abuse. Being exposed to the outside world after time in prison, where everything down to the food is policed, can cause them to once again be exposed to prohibited substances. In many cases, offenders on parole are required to pass drug tests, and failure to pass or intentionally missing a test knowing that they wouldn't pass can result in parole being revoked. There are a number of completely innocent reasons that someone might accidentally break the terms of their parole. However, this can still lead to that same consequence as a major violation of parole conditions, meaning that even if an honest mistake is made, an offender can still be sent back to prison. If someone is earnestly trying to use their parole to get their life back on track, then even a technical or minor violation could cause all their progress to be undone. This can be owing to something as simple as relying on public transport. If a bus gets canceled or there's traffic on the roads, then this can affect an offender attending meetings with their parole officer or missing mandated curfew by as little as a few minutes. Drug or alcohol tests are not always entirely accurate either. In some instances, a failed test might be the result of contamination, a false positive, or other prescribed medication that affects the result. Minor violations should not result in an offender being sent back to prison, especially if they're the result of innocent mistakes or factors out of their control. Any violations or parole conditions are typically dealt with in parole violation hearings held before a judge or a parole board. They make the decision whether or not to revoke the offender's parole, although they are entitled to legal representation during the proceedings. With the right lawyer, an offender committing a minor or technical violation might be allowed to remain on parole without having to go back to jail, or could have the conditions of their parole modified going forward. Now check out how police caught a murderer from a single clue, the Rolex killer, or watch this video instead.